Good evening, Captain Retired Matt Edwards. With the next installment of my Facebook Live Observation Post Report for the 15th of June, 2023. Now, I'm going to take a slightly different approach tonight because I went over to my Member of Parliaments today and I spoke to the staff for 2 hours of stress-inducing bullshit, is what I would call it. So I'll go over that in detail. But first I'll do the few points that I was going to do prior to, elucidating about the bullshit that we have to endure. Number 278 of my numbered list that I posted in my files group. 1976 and the insertion of the Pension Act clawback into Service Income Support Insurance Plan history. Now, the idea was, back in 1976, according to the reference paper put out by Veterans Affairs Canada in 2005, they said they realized that people couldn't live on a pension payable at 20 to 30% based on the table of disabilities. Now, before that, they decided you couldn't get a pension and SISIP long-term disability at the same time, but the government decided to stack those payments to allow both payments to be received at the same time, because nobody can live on 20 to 30% Pension Act monthly payments. Now, I was thinking about you as enterprising soul, but some prick put into the Service Income Support Insurance Plan a clawback of the Pension Act pension, which defeated the idea of getting both at the same time. So some high-ranking general or politicians decided that disabled veterans should get both. But some son of a bitch decided to put a clawback into the Service Income Support Insurance Plan to defeat the intent of Parliament. Now, I cry foul at that kind of shit. That shouldn't happen. Besides, when you are getting both, the Pension Act being an indemnity for your injury and the Service Income Support Insurance Plan being a non-compensatory payment paid in relation to the premiums you paid for to get the insurance, you're not getting overcompensated. You're getting one compensation in the Pension Act, and you're getting not compensation under SISIP. It's insurance money, not compensation. Number 279, DEI/Canada Pension Plan remittance or failure to deduct and remit trust funds. Statutory deductions from the employee's pay by the CRA are supposed to be remitted or sent to Canada Revenue Agency. Now, here's the thing. The government, in the form of Canada Revenue Agency, decided that they should have employment insurance and Canada Pension Plan deductions taken out of long-term disability insurances when the employer is also the insurer. Now, the premise for that is that it's the same source of the funds. You served when you were employed and you got income in the form of pay. Now, after you become disabled, they figured you're getting paid by the employer, so therefore you have to pay taxes on the income. Well, if it's taxable as income, they figured that it should be EI, insurable, and Canada Pension Plan pensionable. So that would result in less money for the person getting long-term disability. Never mind the fact that long-term disability is always less than the amount you made when you were working. You were healthy. You worked. So you get 100% of your pay. They charge tax against the 100% that you made. They also charged a certain amount, percentage, based on the Employment Insurance Act and the Canada Pension Plan Act, but you were employed and you were putting away money for the future in terms of at least the Canada Pension Plan. The employment insurance is different. That's an insurance, a social insurance, that it only takes effect when you become unemployed. Now, so basically the government has set up a system with two sets of rules. If you're not the government, they expect you to take taxes, employment insurance, and CPP out of a long-term disability insurance. Now, that has a cost. And it's not just the amount that they take off of the person, but because those acts require more than what they take off from the employee, then it would cost the government money if they followed the same rules that they apply to other employers. Now, I know I'm going to get into it later, but when I was talking to my member of parliament staff today, I was talking about the rule of law. You cannot, as the government, tell employers that these are the rules. And then when you, the government, are the employer, you can't say, those laws don't apply to us. We're above the law we made for you peons, you peasants, you serfs. These laws don't apply to us, so we are special. Now, being a bit sarcastic and vindictive here, but, I think I've got cause to be vindictive when you ought to treat everybody the same. Either you don't require employment insurance and CPP to be deducted from all plans, or you say CPP and EI has to be deducted from all long-term disability plans. That's the way it's supposed to be. Number 280, bias and the Income Tax Act, Section 61F. Income Tax Bulletin 428 states that Canada Revenue Agency will judge whether an employee pay all long-term disability plan is accurate, but what if there is an actual or reasonable apprehension of bias? Such as my case, when Canada Revenue Agency is both my employer, and if I question the fact about is there an employee pay all plan, which is tax-free, then Canada Revenue Agency is the judge. Now, you can't be both. You can't be the former employer who has the insurance plan and then also be supposedly a separate agency who looks into and decides like a judge whether or not there is an employee pay all plan in place. Now, the irony here is that there's no such thing as employer contributions towards a long-term disability plan or a pension. There isn't. Because every payment that is made is earned by the employee. So in the case of my favorite target, the Service Income Support Insurance Plan, Policy 901-102, the government pays 85% of the cost of that plan, allegedly. And the employee, I shouldn't say that, but the Canadian Forces member pays 15%. And people in the public would say, what a great deal. They get too much money. But the government pays 85% that the Canadian Forces member had earned. The 15% that is also paid by the government, they remit it to, supposedly, manually. Both parts of the payment are earned by the Canadian Forces member's service. In the case of a person having become too disabled to serve and to get SISIP, then there is no employer contribution, really. There's a fiction involved. And the government wants to tax the long-term disability because it would save money for them, because the premiums wouldn't have to be high, because the government gets some back, they get subsidized by the tax. Now, number 281. Review the types of release with respect to service injury. The last, life after service. I don't know what the other one means, but the LAS, life after service. Reports, they're put out by Stats Canada. Last might be a good source, plus the number of people on income replacement benefit. Now, the idea of this is related to one of the topics that I was talking to the Member of Parliament staff about. Now, when you look at the number of people who are medically released, since 1999, these people are supposed to get the Service Income Support Insurance Plan without any fuss or muss. It is supposed to be automatic, based on the fact that, okay, I'll read. I was prepared to talk about this, so I have my Google Chrome page up here with a link to the 2007 report, which covered the period 1993 to 2003, that the federal government, Treasury Board Secretariat, they put out a report on total compensation. Now, the idea of total compensation is exactly what I've been saying, that when the employer pays part of your CPP, part of your EI, part of your SISIP premiums, well, it's included in the total for a different figure than what you got paid, and they call it total compensation. Now, back when they were looking at the Canadian Forces Superannuation Act pension contributions, they said that, the ratio of the employer to member Canadian Forces Superannuation contributions has grown steadily from the period of 1991 to 1992 to 2002 to 2003, increasing from about 2.13 to 1 in the former year to now being 3.54 to 1. So they're complaining about the high cost of the pension, and they're saying that the government puts $2.54 in for every dollar that the Canadian Forces member has, put in to get their pension when they retire, whether it's medical or voluntary. Now, I was talking to the member of permanent staff about this today because I was talking about the contributions, and the defined benefit pension doesn't matter. Okay? And she tried, yes, that's not true. She said, if a person serves, and they get out as a colonel or a general or something, and they serve 35 years, they'll get a higher pension than someone who didn't serve as long. Now, I said, root. That's not the same thing. I said a defined benefit pension is paid on a formula. The formula is 2% accrual rate times the number of years service with a maximum of 35 years. So 2% times 35 years would be 70%, and then they multiply it by your best average 5 years of pay. Nowhere in that formula is a variation of that formula for contributions. You could put $1 in, you could put $1 million in, and you're going to get the same kind of pension based on the formula. See? So all of this whining that they're doing in this report is nothing but a red herring. They are trying to, I presume that the intended audience for this report, I presume that they're trying to scare the government into limiting the number of, the amount of money paid out in a pension. And they're trying to say, oh my God, look how generous, look at how expensive this pension is. When in fact, like I told her, I said, listen, there shouldn't be any contribution for a pension. A person's service should be enough. That's the way it is in many pension plans. Now, the other point, and I'll probably get into this as well in a bit, but they were doing a thing on this chapter about the Canadian Forces, and they were talking about retrospective for the insurance, health, and dental benefits. So they said that, let me find it here. Okay, the cost of this coverage for regular force members and reservists has grown from $9.6 million in 1993 to 1994 to about $38.2 million in 2002 to 2003, based on claims experience. In large measure, the increase resulted from a change in the definition of disability away from requiring that a member be disabled for any occupation in order to qualify for coverage. This closed a gap in coverage whereby a disabled member might be discharged from the armed forces for medical reasons but be ineligible for disability insurance coverage. Now, do you get it? They're saying basically you paid your insurance premiums for nothing because they used the wrong definition of disability. So in order to fix this, and I put air quotes around that if you didn't notice, they decided to make SISIP automatic in 1999. Now, that's enough of that stuff because I was going through my points. Now, let me get into how this, and as a bit of background, I told them 2 days ago, my member of permanent staff, that I will be over at 1:30 on Thursday. I wanted to look at my file, and I wanted to see if they got any the recent emails I sent, and I wanted to have short discussion on some simple issues that I thought they can help me with. For example, okay, let me go through it chronologically and then maybe you understand. So I went in there and I asked to talk to someone. I ended up talking to Ruth, the one who always triggers me. And I knew, even though I was dreading as I was driving over there, I knew that was probably what was going to happen. So I got up there, I go in and talk to her, and I explain all this stuff, and then she tries to gaslight me, as she always does. When I say, for example, I got the Canada Pension Plan disability when I was forced into doing it. Well, everybody does that, she said. I don't care. They shouldn't do it to someone who was hurt in service, especially. Then, when I said, well, I shouldn't lose more than I get. I got $1,000 Canada Pension Plan. I lost $2,650 a month from my 4 insurances and pensions. You shouldn't lose money by getting the Canada Pension Plan, is my point. Now, she didn't seem to get it. I don't think they want to admit that they've made a mistake. See? So then I said, well, I ended up owing $25,000 net after I got $14,351 from Canada Pension Plan Disability in retroactive payment. But Sun Life, Manulife, they both claimed that I owed them $14,351 because I got the money instead of them. Then the public service pension used bridging, and they said I owed them $10,000. So that's $29,000 plus 10, that's $39,000. Then the Reserve Force Pension Plan sent me a bill for $909, which I'll round up to $1,000. So now we're up to $40,000. Now I only got $14,351, so I'm out. I have a deficit, a liability, with my government pensions and insurance of $26,000. Now I said 25, but it just added up to a bit of a different number because I was rounding probably. Now, they still don't seem to get it. That shouldn't be done, and it shouldn't be done in the government. The government shouldn't do what all of the other people do, like insurances and normal employers. The government should lead by example and not screw someone into the ground. They shouldn't. But again, before we even got into that, the very first thing I got into, it might have been a half hour of arguing with her, was about the consent form that they said that CRA and other departments want. Now, they were trying to say everybody does it. All the members of Parliament across Canada, they all fill out a form when CRA asks them to fill out a form. Even though I said, Ruth, the members of Parliament in 1982, they wrote the Pension Act, and they gave themselves an escape hatch. Well, everybody else requires a consent in order to access someone's personal information. The Member of Parliament thought fit to give themselves an exception to that rule, and therefore consent is not required. Now, that didn't faze her. So I said, the rule of law requires that you obey the law. Oh yeah, I know that. Well, I said, ignorance of the law is no excuse. Well, I know that. Well, how come, if there's no exception required, in the case, a specific, very limited case, that the Member of Parliament is trying to help his constituent. So basically, it's political representation, like it's agent principle. And they gave themselves, there's an exclusion that normally you are required to do a consent form, but not in this specific example. So if you then get a personal information, a consent form from CRA, and you go ahead and lay it on the constituent, and you had them fill it out, then you and CRA have both broken the law. Oh, what are you talking about? Well, I said the Privacy Act is designed to protect personal information from the government. Oh, okay. Well, the consent form has personal information, right? Yes. And you didn't need to collect a consent form because there was an exception to the law requiring consent. Oh, if it was like that, then you're saying the whole country's doing it wrong. I said, if they're doing what you're describing to me, that they're filling out a consent form for a Member of Parliament and none is required, then yes, I am saying they're doing it wrong. And as the legislative part of government, being that there are three branches of the government. We have the legislature, Seamus O'Regan, my member of parliament. They write laws. Then there's the executive, like Canada Revenue Agency, and they administer the law. And then if some of the other two screwed up, we have the judiciary. Now, if I have a problem with the executive, I can get it fixed in two ways, I told her. I can go to the lawmaker, and I can say that it's your duty to enforce the law. You wrote it. You have to enforce it. Or otherwise, why bother writing the law in the first place? They could have left Section 8.2G out of the Privacy Act, their own exception for a member of parliament, where they do not require a consent form. Canada Revenue Agency, I told her, is acting as if that does not exist, and they do not have the authority to write law. Now, otherwise, I could go to the judiciary, the judges. I could go to court, and I could say, well, you know, there's this problem with the law that, you know, our lawmakers wrote a law, ignorance of the law is no excuse, and under the Statutory Instruments Act, judges are required to take judicial notice of the law, but laws are published in the Canada Gazette for the general consumption. So, whether or not a person is aware of Section 8.2G, it is a public law, and it has full force and effect. So if you ignore that public law, I said it's well within possibility, not probability, that somebody could charge criminally the people that violate the Privacy Act, Section 8.2G, in collecting the personal information when no collection is required. Then somebody could take it upon themselves to charge them under Criminal Code Section 126, which is a regulatory offense, not a criminal offense, but it's designed to be a catch-all law if an act of parliament does not have a penalty or a fine, some kind of sanction for violating the law, because otherwise people could thumb their nose at the government for this law or that law because they know that it's no enforcement there, no enforcement clause. So the government of Canada put in Section 126, it used to be 115, but now it's 126, and it's about good government. And basically, you can get indicted. It's an indictable offense, which is different than, you know, trying to remember the other name. In the States, they call them felonies and misdemeanors. Summary. In Canada, it's called a summary offense. And then there are hybrid offenses, and then there are indictable offenses. There's no time limit on an indictable offense, but they're more serious. So you can go to jail for 2 to 5 years if you violate an act of parliament, such as the Privacy Act, Section 8.2G, or some other act. So none of this is doing me any good. I'm there getting all flustered and getting stressed out and shaken, and she's not happy. She's not used to people question her. So we get in there and she tries to calm me down with some distracting things about, how's my son? Well, I said, which one? I have two. Oh, I thought you had one. See? So if they used active listening, if they knew about my file, they'd know these things. Well, it's not as important, but I don't like it if someone's going to ask you about one son when you got two. It's kind of stupid. Anyway, so, I mean, it's so fucking frustrating to deal with idiots, okay? Don't get me wrong. I didn't expect much out of them. I said to her, listen, I don't expect you to be able to try to solve my problems, but I expect you, for example, here's one specific instance that I think you guys might be able to assist me. I delivered a letter by hand to Service Canada in 2019, and I asked them to look into the fact that I was unlawfully approved for the Canada Pension Plan Disability. Now that started another 10 or 15 minutes of argument. What are you talking about? That's just your opinion. I said, no. I got a letter from CPP, Service Canada, on the 26th of July, 2013. I didn't open it for 3 years, but they said, Dear Mr. Edwards, you don't qualify for Canada Pension Plan because you don't have enough contributions in a recent period before your application. So it's black and white. That was their legal opinion back in 2013. Then I get approved in 2014. So how did that happen? See? So Oh, she then went and said, well, someone must have looked at your file and said that you met the definition, which is this, this, and this. And I finished it off for her. I said, listen, you're talking about Section 44 of the Canada Pension Plan Act. And it says that a person must have a severe and prolonged illness. And they must have the minimum qualification period payments that we were talking about. And they must be unable to do any occupation. So that's the rules. Now, I was told I didn't meet the rules, and then I get it despite that, so I find that very suspicious. Oh, why do you think they're doing that? Are they out to get you? I said, yes, and then she looked at me very skeptically. Then I said, no, listen, here's the real thing. I am a threat to them because I'm making such waves about their fraud, okay? I got approved, and it hurt me. It cost me money. It is a savings to the government, and it's at my expense. Now, it's not just me that this happens to. It's just that in my case, it's so extreme because I had 2 pensions and I had 2 insurances. If someone only has 1 pension and 1 insurance, which is more than likely the case for most people, then they won't lose as much money as me. It's simple logic. But as I kept talking to her, wasting my breath, I said, listen, you said you were working in Ottawa in Parliament between these years and that years. And I said, you probably even saw the Minister of Health and Welfare, Judy LaMarche. And I said, it's very important that the spirit and intent of acts get followed. And they said in the answer, because I found a copy, I went through it. And she said in the 9th of November, 1964, that, the Canada Pension Plan disability will provide help as of right instead of help as of need, that if a beloved breadwinner became disabled, then they wouldn't have to worry, basically. So here's the thing. If you pay into the Canada Pension Plan and you become disabled, then you should get a Canada Pension Plan disability pension. It shouldn't have a 35 to 40% approval rate. The approval rate should be 100%, to which she scoffed and said, well, they can't do that. What about the doctor's reports and stuff? I said, it got nothing to do with it. The intent of the Act in 1964 was to pay a person a disability pension when they couldn't work. That is it. They have to pay it. Somehow, over the years, they have put into the law, and I told her about Gronowski, Supreme Court of Canada, 2000. I said, do you know the difference? Is there any such thing as a conditional right? Okay? So, Minister LaMarche said you have a right to the Canada Pension Plan, but, somebody put conditions on that right. And, isn't that a privilege instead of a right? Like, I should have the unqualified right, or reasonable limits on it at least, to get my disability pension when I become disabled and I paid into a pension that has a disability portion of that pension. Which brings up another point I made, and I've made this point here many times. I said, listen, the Canadian Forces has 2 different pension plans. They have the Canadian Forces Superannuation Act for regular force people, and they have the Reserve Force Pension Plan for reservists. Now, if I get medically released, I don't get my pension as a former reservist. But if a regular force veteran becomes disabled, they get their pension. So I said, that isn't right. You can look at this case and you can try to say, and she said, well, they must get better benefits than reservists. I said, yeah, but you're not supposed to treat people in the same situation differently. But recently, and I'll link it back to the SISIP problem from 1999. Essentially, I paid into the pension, and they didn't want to cover me for the risk of disability. When I called the pension people, when I applied, and they sent me a letter maybe, they said I had 2 options when I got medical release. I could take a deferred annuity, which is payable at age 65, or I could ask for a return of contributions. Now, me being the researcher that I am, I said, what about the immediate annuity? Like a Canadian Forces member who gets, a regular force member who gets medical release gets an immediate annuity. Oh, well, you don't have that option. I said, well, why not? Well, the definition is this. You see, here's the problem. They write laws, like they put a different definition of disability in the Reserve Force Pension Plan than is in the Canadian Forces Superannuation Act. And they're too stupid to realize that you cannot put a definition in an act and define it differently in the same act. You can't do it. It's crazy. But why I'm mentioning this in that context of the 1999 SISIP long-term disability case, the problem back in 1999 was caused by the exact same thing. They said that the definition of disability was the any occupation disability definition, and therefore you had to meet the definition or you don't get your long-term disability insurance. Well, the Reserve Force Pension Plan administrators were telling me that I had to meet the any occupation disability definition instead of the own occupation disability definition, when the upshot of the reasoning why the government admitted that they did it wrong is that the long-term disability insurances have two components. They have a 2-year period with the own occupation definition of disability, followed by up to age 65 long-term disability payments if you meet the definition of any occupation. So basically, they need to fix the problem. And they need to fix the problem by saying that any medical release will result in a person getting their pension, because pensions are property, I said. Clark, Supreme Court of Canada, 1990. Now, I mean, we got back onto the SISIP thing, and I was telling them how they didn't want to pay me. First, they said, or it might have been second. First, they said, you got to prove you were injured on duty, which I did. So I floated the idea, which I came up with recently. Listen, if they made an extra condition that I had to satisfy to get my insurance, when it comes time for them to want to remove me, they should have to go through extra steps. Instead of just simply, we are going to cancel your insurance. Well, I had to go through a more difficult time to get my insurance by proving I was injured in duty. So you know what? You should have to do more in order to stop my payments. I think it's a pretty goddamn good argument. Never mind, like I told her, that insurance is sold and implied into the contract is an utmost good faith duty applying to both me and them. Now, if you lie, you're obviously breaching the implied duty of utmost good faith. And I had explained to her that I want them to call the Minister, write the Minister of National Defense, and ask them to look into the false reports being put in on the Service Income Support Insurance Plan, where they put in Manulife as the payer, when, in fact, the payer is ultimately Canada. Sure, Manulife makes a payment, but the payment is merely a pass-through payment, where the government of Canada is paying the disabled veteran. And where I got that from, besides it being common sense, was the Dennis Mnuchin class action, where the judge said that the Chief of Defence Staff was the underwriter. Now, I don't believe the Chief of Defence Staff is the underwriter, okay? I think it's actually the Minister of National Defence, because the Chief of Defence Staff reports to the Minister of National Defence. So I think it's incumbent upon my Member of Parliament to inform the Minister of National Defence that there is a potential legal problem whereby false documents, forgeries, are submitted to Canada Revenue Agency for an official government purposes, taxation. Another recent idea I had, and I don't know if I put it into my list, is fruit of the poison tree. Okay? When someone is dishonest, it's also called the illegality doctrine of illegality in court stuff. So if you get caught doing something illegal, you're going to lose, okay? You don't get to go to court, do something illegal, and then win. You're not supposed to condone, encourage illegal, illicit activity. So if you want to tax the long-term disability known as the Service Income Support Insurance Plan, Sun Life Policy 12,500G, the Public Service Management Insurance Plan, and the Great West Life Plan, you want to tax those? You can't lie on the tax information slip. You do so, you invoke fruit of the poison tree. If you want to tax someone, you would have to follow the tax information slip with the correct, legally correct, factually correct payer. The people who actually paid, not the people who made a figurative You had to look at who made the literal payment. Now, some people would argue, well, that's no big deal. That's a minor item. We would just change the name and you would still pay taxes. Well, see, that's where we bring up the rule of law again. What would they do if anybody else but the government did the exact same thing? I bet they'd go to jail for a long time. If somebody was trying to screw over somebody and they put false documents into Canada Revenue Agency or any other government department, I suspect they'd end up in jail. Okay? Look, I mean, I think I'll call it quits there. I got a headache. I'm tired of this crap. I mean, she asked me, Ruth, I'll leave you with this as the last point. Ruth said, well, why don't you go to court? You could probably get a group of people and do a court case. I said, well, why should we have to do that? I said, I'm going through the political avenue because I think it might help you save some money in damages. If you came forward and admitted that you made a mistake instead of someone having to drag you to court to prove it, and you're kicking and screaming the whole time saying this and that don't apply and trying to avoid legal liability, well, you might have the hammer come down on you. So, I mean, I'm trying to help you guys out here. I'm telling you about a problem. And I said one of the main things about the government is you are supposed to have oversight over the people that enforce the law. I don't know. I think that I might have came across committees in Parliament before about, I know that SCANDA, the Senate committees and stuff. But, like in the States, for example, because I watch a fair bit of CNN and stuff, and they have this Judiciary Committee and stuff, and they have the Defense Committee and all that stuff. Now, those are supposed to be the oversight of the executive. So the lawmakers have a job, a duty to oversee the people who are supposed to enforce the law. Now, so when you have the Service Income Support Insurance Plan not obeying things, not doing the right thing, and they know about this stuff, right? I mean, it's not new. I'll mention this last point because I was going to shut up, but I never got to use it. But, I was talking to somebody a couple of days ago at that office, and I think it was Ruth again, and she brought up the will of the people. Well, see, I was going to use that today, and I skipped my mind because I was so agitated. But the bridging part of the Canadian Forces Superannuation Act, the Public Service Superannuation Act, and the Royal Canadian Mounted Police Superannuation Act, Peter Stauffer introduced the Private Members Bill, and a majority of members of Parliament voted to end bridging. Now, that's called the will of the people. So nobody can try to defend the bridging laws and say it's only a law that reflects the will of the people. It's contrary to the will of the people because they voted to end the clawback of the SISIP pension, using the Pension Act as a clawback. The same time when they voted, they also decided to end bridging. Now, there was some legal technicality. It might have been election called, never got implemented or nothing. But the spirit and intent of our elected members of Parliament, they voted on it in Parliament. It was recorded for posterity, and they decided this wasn't fair. Now, I think that is compelling evidence to prove everything I'm saying is right. Okay? What do the people of Canada want? Well, the elected representatives we put in the Parliament voted to end bridging. Now, on that note, I'll end my chat for tonight. Try to watch some TV or something and get away from this crap and try to get rid of this headache. But I hope, that eventually I get some satisfaction out of this and that the people I'm trying to help, because it's not just me, I wouldn't be doing this. If it was just me, I'd probably just go get a lawyer, sort it out. But it's happening across the board. Not always to the same extent in every case. But this is a systemic issue, and they need to come up with systemic fixes. Thanks for watching, and have a good day.